Let's analyze the judgment in the case of Wahid Gul Khan and Mumtaz Ali versus Province of Sindh and others. The Supreme Court of Pakistan, in its appellate jurisdiction, considered the order dated 15/12/2021 passed by the High Court of Sindh. The constitutional petitions CP No. D 756 of 2013 and CP No. D 3575 of 2013 filed by the petitioners were dismissed through a consolidated order. Here are the key points from the judgment. Background. The petitioners had applied for a job in the Food Department, Government of Sindh, based on an advertisement dated 14/02/2010. They passed the written test and were called for an interview. However, after the interview, they received no information about the result. The petitioners later learned that certain candidates were appointed who had not appeared in the written test. Consequently, the petitioners filed constitutional petitions challenging the appointments. Contentions. The petitioners argued that the impugned order failed to consider their grievance correctly. They claimed that the alleged appointments were made in violation of the law and should be declared illegal. The petitioners asserted their entitlement to be appointed. Law officer's response. The learned law officer contended that interview results cannot be challenged in the writ jurisdiction before the High Court. According to the law officer, the impugned order was well-reasoned and did not require interference. Court's analysis. The court addressed two key questions. Does merely passing a written test and being called for an interview create a right or interest in favor of candidates? Can interview results be challenged in the constitutional jurisdiction of the High Court? The court held that mere qualifying for an interview does not automatically create a vested right for appointment to a specific post. The exercise of constitutional jurisdiction by the High Court does not grant candidates a fundamental right to enforce appointment based solely on interview results. The appellants, petitioners, had not received an offer of appointment and their appointment was subject to clearance by the Establishment Division. The court considered the ban on fresh recruitments and the discontinuation of the centralized system of recruitment in November 1996. Conclusion. The court emphasized that an interview is inherently subjective. It clarified that the High Court's jurisdiction does not automatically grant candidates the right to challenge interview results. In summary, the judgment underscores that passing an interview does not guarantee appointment, and the High Court's jurisdiction has limitations regarding interview results. If you have any further questions or need additional details, feel free to ask.